Thursday, January 19th, it is 7 p.m. With us tonight, we have, for the zoning board, we have Associate Member Judy Conroy, Member Dave Anderson, Member Jane Coffey, Drew Delaney, Vice Chair, I'm John Lee, Bob Fitzgerald, Mark Major, and we have Steve from the zoning board staff, and Patrick Deshawn from the Community and Economic Development for the town. And with us, we have Town Council tonight, George Pucci. Good evening, George.
Good evening.
Okay. The first case is a continued case, case number 2116, Wall Street Development Corporation. This is for Darwin Lane. Comprehensive permit pursuant to Mass General Laws 40B, Section 20 through 23, as amended, for the construction of 28 townhouse-style condominiums with 6 buildings. And this was continued from back in December. So, we have the applicant with us, and if the applicant wants to, at this point, present what the new proposal is, I believe it's been revised. This also gives people in the public a chance to see the revised plan, what's being proposed. And then we'll go from there. Yep, set it up so the board can see it, and all this has been, Patrick, this has been online, right?
Correct.
Yeah, so this has been online, so maybe some of you have seen it. I hope you have the revised plan.
Wall Street Development Corp. Can I do this while I'm talking or no?
I wear my mask. You should wear yours too.
Okay.
Good.
So, as the board requested from the last meeting that we had, the continuance, that they requested us to provide a conceptual plan of what our proposed modification to the application would be for 12 single-family homes in place of the 28 townhouses that were originally proposed on the site. We provided a concept plan to the board, and what you see here displayed is a conventional subdivision with 12 individual single-family lots. Each would be fronting on a new roadway that would be constructed, and the homes would be comparable to the homes that are currently built on Darwin Lane and Queens Court. In addition, we also submitted a number of photographs of homes that we've built that are considered for this location, all of which are comparable to the homes that are currently existing on Darwin Lane and Queens Court. These are homes that Wall Street has built in Walpole and in Norwood and in Norfolk, the last 3 subdivisions that we've built. So from that standpoint, the board asked us to present this information for consideration on its decision on whether to waive the safe harbor provision that they're entitled to in exchange for Wall Street modification of the application to limit the development to no more than 12 single-family homes on the site. And I think our attorney had presented a draft agreement to town council, and not sure if the board has reviewed that agreement, but we're interested in working with the town and the board to continue that dialogue and see if we can come to some arrangement relative to that agreement. So that's that's pretty much it. I have our attorney, Jay Tallerman, with us. If there are any questions the board has, we're happy to answer any of those questions.
Okay, thank you. Okay, so board members, if you recall last time, and I'm just saying this for the public, the town has reached what's called safe harbor, which means that for the, until next year, we do not have to accept, what, is it next year? What,
So it's a 2-year safe harbor that is open until April of 2023.
yeah, 2023, safe harbor. So we do not have to accept, or we can deny 40B applications because we have reached safe harbor. At the last meeting, some board members thought it was worth keeping open so that we could see what a revised plan of 12 units would be. And Mr. Petrosi, would you put it back to the 12 unit plan? And one of my thoughts was, the board is aware that this could come back at some point. If it's denied because of safe harbor, it could come back as a refiled 40B in the future. And some board members thought we should at least see what was being proposed by the applicant. And what we have here is, it shows the 12 units on the parcel of land as proposed by the applicant. So that brings us to where we are now. And we'll talk about this agreement, but town council's here. The town council can help discuss that if we're gonna move forward with that. So board members, does anybody have any questions on this 12 building, 12 single family home application? Okay. Oh, okay, Judy?
Okay, I'm just going to run through a little timeline, so bear with me. On September 10th of 2021, we received a certification of approval for safe harbor from 4/27/21 to 4/26/23. On October 13th, 21, this board, at a meeting, voted 5-0 to invoke safe harbor. So far, so good? Okay. On October 18th, 21, there was a letter sent to the applicant regarding the opening of the public hearing, and it also, I believe, went to DHCD. Now, the November 24th letter from DHCD clearly states in its conclusion of its 5-page letter that this board met its burden of proving satisfaction of the grounds for asserting safe harbor. It appears suddenly at our December 15th zoning board meeting, the applicant had an appointment to request that this board reconsider safe harbor by asking the board to consider 12 units as opposed to 28. Now, I'm not a lawyer, but it's kind of in the black and white, and it's also in a letter from attorney Dennis Murphy Esquire dated December 22nd that I'll paraphrase. The denial is a denial is a denial. We denied the application on Darwin Lane. End of story. It's not a, oh, wait and see, and let's see if we got a better deal. That's not how I looked at a denial. Attorney Murphy stated in his letter that safe harbor applies to a particular project, and I quote, "Once invoked, upheld, and not appealed, it cannot be revisited." So my question is to this board, why are we going forward with this?
Okay. So at the last meeting,
I was here.
the board voted, and it was 3 members voted to keep it open, 2 members voted to close, to close it and probably use safe harbor. So I'll turn it over to town council for legal. So that just brings you to where we are. So town council, is Attorney Murphy's opinion, you agree with that, that this is, it's gone, it's been, we invoked safe harbor, and that's the end of this?
First, good evening, Mr. Chair, members of the board, George Pucci from Town Council's office. I respectfully, John, I'd prefer to decline to comment on Attorney Murphy's letter. I don't think it's a fruitful exercise. I can bring you up to date where you are. You haven't denied the application. You've continued the hearing. You invoked safe harbor on the first night of the hearing. You continued it for that process, and the applicant did file an appeal, which was denied by DHCD. So you have your invocation of safe harbor was upheld. You continued the hearing to hear about a modified potential project. And that proposal was made to you with sort of a quid pro quo, that the applicant would agree to limit to this reduced size project and would not seek approval for the larger 40B project. You'd go forward, they're proposing that you go forward and hear it despite safe harbor being upheld by DHCD, hear it as a 40B, and act on it. You do not have to do that. You're free to vote to deny the application tonight pursuant to the prior invocation of safe harbor. But you, as you said, you continued it to tonight to get a look at the proposal, the reduced proposal, and to decide whether, you know, from a risk management standpoint, does it make sense to try to go forward with a reduced size project so that you didn't face a potential larger project down the line, depending on what happens? So that sums up where you are tonight. You're not in, you don't have to go forward with any further hearing on this. You're free to close the hearing right now if you want and vote to deny the project.
Okay. So one of the reasons why at the last meeting, and I know people from the neighborhood were opposed to keeping it open, but board members voted to keep it open to see what a 12-unit project might look like. And so that's what it is. And do any neighbors have any comments or questions? Okay, sorry, before I open it up.
If I just may real quick, I just want to recap another potential point of clarification, and anyone can correct me if I'm wrong. One of the reasons why I'll say I voted to continue to kind of talk about it only because I believe we do have safe harbor in Walpole right now, but it's my understanding that there is a date, an imminent date in play. I think it's in April at some point, where some of the projects that were approved in Walpole, that were approved through the 40B, process, should they not reach certain milestones by that date, would then open the town back up for 40B eligible projects.
And when you say, just to be clear, when he says April, you're talking about April of this year?
Of this, I believe, and you can correct me if I'm wrong, anyone on the dates, and Ben, Patrick may know, but I'll just give you an example. Let's just say by April 15th, if a permit isn't pulled on a project that was approved through the 40B process by said date, projects in the pipeline eligible for 40B would then be eligible to move forward through 40B. That was my understanding.
So I'll speak to that. So what that essentially is the project that got the town to safe harbor. If no building permits are pulled within a year of when that comprehensive permit was recorded, we lose a year of safe harbor until those units are put back on the subsidized housing inventory. So once a building permit is eventually pulled for those projects. So it's a time-lapse provision within DHCD's rules and regulations. That's certainly a possibility. But keep in mind right now, we're still working under the premise that we are within safe harbor. We are within a 2-year safe harbor. So that is just one thing for the board to be mindful of. But the facts are right now, we are within that 2-year safe harbor.
And I just wanted, the point of clarification was only from a risk management standpoint. My thought process around considering or talking about this was in the event that we would fall out of safe harbor, not to say or speak on this project at all, is it would be worth having a conversation about, in the event that we were to fall out of safe harbor, to not have the proponent back before the town in whatever April is, or the date is from now, in 3 months, and be able to then just appeal it, have the 40B aspect of that project be able to be invoked and not be in the same position that we're at right now, where we can have a conversation about it. Does that make sense?
I understand it. Okay. Any other board members?
I just had a question for Patrick. On that time lapse, when I read that, it says 1 year, but it also has a time frame of 18 months. So the way I read that was if a particular project didn't meet its building permit application and approval time within that 1 year anniversary, they have 6 months to continue to pursue their building permits, and we're only out of safe harbor for the time frame if they did it on the 2 weeks after the anniversary of the building permit issue. Is that not correct? It's in the definition of timeline, time lapse,
I don't know. would
that
have to look.
that you sent to me today.
So the way I read it, obviously, if I go back through the board, so it's a year from when the building permit, so it's a year from after the comprehensive permit, if the building permit isn't taken, then I believe it's that 18 months kicks in from when construction begins. And I'll have to
There were
look
two
through.
18-month timeframes. One was construction.
Mm.
If construction didn't happen within the 18 months of the anniversary of the issuance of the approval, then the comprehensive permit approval
Units would fall out.
disappears.
Yeah.
Just goes away, that project is dead in the water. But they have up to another 6 months to continue to pursue their building permits. That's, I don't have it on my phone here, but
Do you have the
that was
second?
under the definition of time lapse.
Yeah, that's the way I think we reviewed it with town council originally, was that it's a year from when the from when the comprehensive permit is
So we'd
initially
be
pulled.
off, but if a
They
month
fall off
later,
the inventory.
if a month later, after the 1 year, so in the 13th month, they were issued a building permit, we would only be out of safe harbor for that 1 month.
Oh, yes, yeah, no, yes, you're correct. If
Okay,
they are
all right.
issued afterwards, then you say
So
yes. Sorry.
So the ifs and the what ifs, and what if I cross the street and get hit by a bus, or a meteor hits town hall, the what ifs. That project has a little wiggle room to get their building permit
You are
up to
correct.
6 months.
No, there is a wiggle room, but there is the possibility that, like, as you mentioned, if it does fall off, there could be it could be that month in between. That's a possibility, but at the same time, like I mentioned, we have to work under the premise that we are within that 2-year safe harbor as well.
Right.
So I think that's kind of the main point to get across, that where we are right now is we are within a 2-year safe harbor. We're looking, as you point into the what ifs, we don't know what's gonna happen in 3 months. We have to work with where we are right now within safe harbor,
Okay.
which
But
is a 2-year safe harbor.
if that 13th month, and they filed, but in the 12th month to the 13th month, that window of time, someone could come in and apply for a 40B, because
Yeah,
we're,
correct.
quote, out of safe harbor for about 30 days.
Correct.
And,
And then those units could be re-added to our safe harbor afterwards. Once the
Correct.
building-
Yes.
You are correct. So there is
Okay.
that
But it also
slim
gives-
option.
It also gives somebody there might be another developer out there sitting with a plan, just waiting for the town to fall out of safe harbor and then come in and drop the plan.
that's okay.
And, but the point is that once the plan's filed, we cannot then go back and say, oh, a month later, we're in safe harbor.
I understand
Okay,
that.
because once you come out of safe harbor, and if a application is filed, we have to take it.
Understood.
Okay.
Understood. But in the meantime, if that 13th month happens and the developer gets to his building permit, we're back in safe harbor.
Correct.
Okay, just want to make sure that
No, you're
everyone understands that, because it does, to me, that, as town council said, this is temporal. Well, temporal looks to me like we have the year for the project in South Walpole. But they also have an additional 6 months, so, to get their building permits lined up. We'd be out of safe harbor for 6 months, but it doesn't make that project go away. Okay.
I just want to be clear to sum up, and you might, I would never intrude on how you run the meeting, John, but I just want to sum up. You're in safe harbor now. You've invoked it timely. If you don't want to hear this any further, you can make a motion tonight after you close the hearing and deny it. You don't have to think about hypotheticals or any of that. The fact is, it's all teed up. It's been explained ad nauseum. Mr. Petrosi talked about his counsel giving you a proposed agreement from counsel. Yes, of course, I turned that over to you. It's self-explanatory. I think you've all had a chance to read it. I would specify before you do anything that who your voting members are on this application. I believe it's your 5 full members, correct? They were all here the night that you invoked.
Jane? Oh, wait.
I was here.
Okay, Jane was here for that, yes. Okay. Yep.
So I would, you know, in the event that you do a vote, I would just make sure that we're specifying the 5 members that are
5 regular
eligible to
members.
vote. Right.
Okay.
You weren't here. I wasn't here.
Maybe we should have Patrick
When he
just
came to
confirm,
talk to us.
based on the minutes,
He's gonna
who
look
was here and who voted, just to be clear. I think there's some.
I'm doing that right
concern
now,
that-
to be clear.
concern that Mary Jane may not have.
Okay, then I wasn't.
She can always mull on
Huh?
it.
Oh, she has watched it before tonight.
Yeah.
John, I might not have been here the night, the first night,
Continue.
but right. But I did say I could, invoke the, act.
Mullen rule.
The Mullen rule, yes. I did read it all. I actually watched it on TV too.
Okay.
So I should not have been. Pardon me?
I understood what you were saying.
Okay.
Okay.
You should try not to, everybody has to hear when you're talking at the board, and I think I heard you,
Oh, okay.
Mary Jane, that you said you did exercise Mullen,
Yes,
that you
absolutely.
reviewed the tape from that hearing session that you
Absolutely.
missed. So you have 5 eligible voters on it. I think that sums it up, what you were saying.
Patrick's gonna tell us.
So on the 13th is the day that you opened the hearing. Mr. Anderson was not present for that hearing, so Mr. Major, as the associate, filled in to vote to continue on the 13th. So those were, so Mr. Fitzgerald, yourself, Mr. Delaney, Ms. Coffey, and Mr. Major were here for the opening of the hearing.
Okay.
And that's how I would do it if I were you, then have those 5 be the voting members on this.
Okay. But one of the things, because the people of the neighborhood have to live with either this or something, the potential of something in the future, do people want to comment on the 12-unit plan, or how do you what have people thought, your thoughts? You're the folks that live there. Please come up and identify yourself and speak.
Thank you, Mr. Chair, members of the board. I'm Dennis Murphy, the author of the letter that Judy referred to. The folks here have hired me to come and try to convince you, but don't take my word for it. Before I say anything, let's answer the chair. Who wants the board to make a deal at 12 units? Raise your hands. Who would like the board to hold firm in its safe harbor invocation and make the applicant prove the 28-unit project that's in front of the board? Thank you. So I have 3 quick points that I'm not going to repeat what's in my letter. The first point is the legal consequence that Judy raised about the DHCD. First of all, you would have no reason to know this. I've been doing 40B for a while. This is the very first time ever that a board has prevailed on safe harbor from DHCD, ever. So you won, congratulations. That has a consequence because I sat where you did on my town board for a long time, almost 10 years. When I sat there, I never thought I had the authority to overrule a state agency, but that's what you're being asked to do. Under the rules, you have 15 days to invoke safe harbor. That 15-day period is gone. Here's how I think it could go. If this application were withdrawn and a new application were filed, you would have the right and the ability to reconsider safe harbor. It's a brand new application, up to you whether to invoke it. But I don't think you get to do a do-over of something that's already happened. You won on appeal, and there is a further appeal from that, but the applicant opted not to do that. So as far as that's concerned, for this application, the 28-unit project that's in front of the board, safe harbor's over. My second point is, just to be really clear with the timing, I have a letter, I'm sure you have it too, from DHCD. It's dated September 10th, 21. And it says right on it, you're in safe harbor April 27th, 2001 to April 26th, 2023. That's a certification of your progress under your HPP, your housing production plan. It relates to a regulation. I'll just tell you so you know what it is, 760 CMR 5603F. That has to do with housing production plan certification. Nobody can ever take those 2 years away from you. If every building were vacated, you're still in safe harbor through April 26, 2023. No matter which units may or may not become eligible or come off or anything like that. You got a certification. You have something even better, which is an adjudication from DHCD that affirms their certification. So just to be clear, the regulation that people were talking about that has to do with the lapse when a building permit is not applied within a year or an occupancy permit is not applied within 18 months, that's when units first become eligible to be put on the SHI. It's actually a different regulation. Just because units that this board approved for the Omni project may become ineligible doesn't mean you lose your 2-year safe harbor certification which you were given. So my third point is more discretionary. So even if you did have the authority, let's say I'm wrong, and on the legal points, these are the folks who live in the neighborhood who will actually be the ones to bear most of the brunt of the risk that you were trying to hedge against. And so I would just pay attention to what they want in your decision. The last point I'll just make is a kind of technical one. In any permit proceeding, you know, it's kind of a formal thing. You have to have an application. You have a concept plan, but there's no application for 12 units. So I think once we decide, if the board were going to hear 12 units, there would have to be a new application filed. It can't be a negotiation. It's a permit proceeding. In order to have a hearing, you have to have an application. Right now, the only application before the board is for 28 units. Thank you very much.
Okay. Thank you. Okay. Board members, any questions or comments?
I just have one question for Mr. Pucci, I guess. And I apologize because I kind of know the answer, but to confirm it. If we waited till April 26th of 2023 and we happen to fall out of that 10% threshold, could the applicant refile for 50, 60, 80 units in this location for a new application for 40B?
Well, then, yeah, all bets are off.
Okay, I just wanted to make sure that
Yeah,
we
and the
understood
way
that
they're
there.
presenting this one is a modification down from the original application, so.
Okay.
And I'm sure Attorney Tallerman has, you know, an opposite view of the law that Attorney Murphy spoke to you on. That's why I would recommend, and it's not my place to, you know, say where I disagree or don't with that, or, because I don't want to cross over to advocating on behalf of the applicant on this. You know, if you have questions on the legal issue, I'd recommend you hear from Attorney Tallerman on the other side of it. Otherwise, as I said, you get the safe harbor, you've invoked, you've continued the hearing on that application. You're free to proceed on a modified proposal, or you can close the hearing and deny tonight.
Okay.
I'll be really brief. I'm also not going to engage in a competing legal opinions. I disagree with Dennis, who I've known for a long time. He's very competent. He's a friend. He's a very good attorney. I agree with the analysis that's been presented to you by George and Patrick. I think it's accurate. I think it's appropriate. The only thing I want to add to this, and you all have the agreement, I'm happy to answer questions about it. It's pretty straightforward. George and I have spoken a little bit about it. It's subject to further conditions or approvals. This is not, I want to be clear for the benefit of the board and the neighborhood, this is not 12 units as shown or the highway. That's not what we're presenting. What we're presenting is a concept plan, which we'd be willing to use as a modification to the current application, that starts with this 12-unit project in this configuration, go through all the normal peer review, all the normal analysis, all the consideration of any potential condition that you would otherwise impose with respect to the configuration, the shape, the size, the color, all of that stuff is still on the board. We are not suggesting you approve 12. We're suggesting a robust hearing on 12 with a discussion back and forth on the kinds of things that this board does well. That's all. So I'm not going to get into the legal stuff. I don't think there's a benefit to that.
That's where we know we are.
Yeah, I just want to, state it for the record that if there's anyone thinking that we're going to walk away if we don't get 12, that's not the case. We want to engage in a hearing that starts with this plan, and we have a good discussion about whether it's a good plan or not. So, thank you.
Thank you. Board members, anything else? So we have some decisions to make here tonight, and the voting members, how do you feel about continuing this or closing it? And, we understand the risk mitigation. That's what I think some people were trying to do. And clearly the neighbors feel a certain way, so. Anybody have any comments?
Well, I'm opposed to this modification, no matter. I think that the town should uphold the safe harbor as the decision has been made. The applicant has he's had a lot of projects with the town, and it hasn't been without multiple issues. But I do think that we should not muddy the waters. The idea of trying to modify a decision that has been made and is very, very rare to get, as was discussed tonight, to get this board, this housing authority to agree with the town over anything. And I don't think Walpole should be the first town that tries to modify a decision that's already been made, that the people within the community who live there very strongly oppose this. And I think in deference to them, if nothing else, the decision has already been made. And I feel it would be almost unconscionable for us to turn around and say, that doesn't matter what the state said, and it doesn't matter what you say, but in fact, we're going to modify this. So I don't think we should muddy the waters. The decision has been made. And I would say many times, if you don't stand for something, you stand for nothing. And we as a board felt that this, we've been over it and over it and over it. And the discussion last week, and I firmly, I could understand, and I think it's appropriate if the board members felt, some of them felt they wanted to look into this a little further. Somebody raised the issue, well, the applicant spent a lot of money doing the plans for this and everything. That should have absolutely nothing to do with this decision. The decision has been made, and I, for one, am going to stick with it. Thank you.
Okay. Thank you, Jane. Anybody else?
Yeah, no, I was one of the members who voted to continue the hearing to hear what the applicant might propose. My principal concern is, I think, already been stated, but it just takes the one day to fall out of the safe harbor for applications to come through the door. And, in my experience, there are lots of folks who monitor this very closely, and, they watch the clock, they check with the clerk. If we're out of safe harbor, the application gets filed, and we're back to square one. So my hope was that we would, see something that might be more palatable, thinking that that there is a significant risk of a larger project at this location in the future, whether that's this April, a year from April, who knows when that might be. So that was my concern. in looking at the revised plan, it still looks very dense to me. And I don't know that 12 units is really even going to move the needle for me in looking at it. Just in terms of the cluster of homes, right, you know, adjacent to the other homes and such. So I'm not in favor of this particular conceptual plan, and you know, but I thought it was worth the effort to see if we could come to some sort of resolution on an appropriate size that would be palatable for folks before we, you know, open the door for potentially larger projects in the future.
And I think that you all have spoken clearly what you think of the 12-unit project, so, okay. Any other board members with anything on this? Okay, so now comes the question, do we want to close the hearing? And town council guide me on this. Would the next step be, if the board decides to close the hearing, we can close the hearing and then invoke safe harbor?
Well, you've invoked safe harbor. You would be then, you know, moving on a denial decision.
Denial
I
of the
provided
decision because we have safe harbor.
pursuant to the invocation, yeah. I provided a
I have
form
it.
of motion in the event that happened.
But do we have to close the hearing first?
Yes.
Okay.
And I would do that by motion if you want to close the hearing.
Yep.
And then if you think that the consensus is that you're headed toward a denial, I would recommend the language that I proposed to.
Okay. Yes.
Mr. Chairman, may I just make one further point? There is another alternative, that if the applicant wishes to have the board hear its 28-unit proposal, notwithstanding safe harbor, that's a viable path. You could have a public hearing, knowing that they don't have a right to appeal, but even towns that are over 10% can use 40B to develop affordable housing. So it's actually a level playing field where there's no threat of the usual 40B outside of safe harbor, that if you don't give me what I want, I'll go get it from the state and appeal to HAC. It's more like a subdivision or any other proposal where I have to come before the board and sell you on the merits that it's the right thing for Walpole and for the neighborhood. So you don't necessarily have to deny it. You could invite the applicant to proceed with their 28-unit proposal. Thank you.
Can I make a comment?
Yeah.
Do you mind
What's that?
do you mind if I make a comment?
No, go ahead.
I was one of the members who voted in favor to listen to the applicant's reduced application or modified application. I'm not in favor of 28 units. I'm not in favor with the depiction that is shown before us tonight, but I do believe that there will be a development built on this property at some point. And though we are in safe harbor, and we've reserved the right for the next amount of time to protect this area from all the people who are sitting here tonight, I think that there is some leverage in a discussion to see if this can be modified to something that some people can find palatable. Now, I can understand that a lot of people here, obviously by the questionnaire that the attorney took for them, did not seem to go in favor of that, but I believe that we always have the right at any given point to invoke safe harbor and close the hearing and deny the applicant at any given point in the process. And I think that though I don't want to waste anyone's time, I think it's certainly something to ponder on. But thank you very much, Chairman.
Okay. So comes the question, we can vote to, if people want, if the board wants, we can close the hearing tonight. And then vote on it tonight.
Yes.
And, you know, probably a denial, and because of safe harbor, right? Okay. Board, does anybody want to keep this open further, or you comfortable with it?
I'm done.
John, not that it matters, but just point of clarification. The potential date, if permits should not be pulled, that we fall out of safe harbor is April 2022 or April 2023.
Okay.
Meaning.
I know what I'm gonna ask Patrick, because I know what number is in my head.
Yep, I just want to clarify.
What was that?
If permits aren't pulled for the South Walpole project, when would we be falling out of safe harbor? April of 2022 or 2023?
Let me just grab the date.
You know, I just have to interject. I'd be careful about, you know, as Attorney Murphy had recognized, you know, this is the first one that you have something that was appealed and upheld by DHCD, okay? So if somebody wants to hand you an opinion from the state's highest court, the Supreme Judicial Court, that says X, Y, Z, black letter, that's it, that's what I would proceed under. But you're talking about areas and regulations and state administrative bodies that can rule in different ways. And whatever happens hypothetically, I would be very careful about making your decision on hypotheticals.
100%.
Because there are very few definitive answers on those types of issues. And I've had many municipalities that we thought would not be in safe harbor that did end up being in safe harbor, and vice versa, you know. So to get into detailed speculation with like a decision tree based on a regulation or an interpretation of a regulation, I would caution against. And you know, I have to be respectful. To proceed with a 28 unit project, you know, reserving your right to invoke safe harbor at any point, really, you have limited resources, and to engage in that errand really seems really frivolous, to be quite frank. So,
And I even said at the last meeting, we should stay with the process, and the process allows a denial, an appeal, or whatever. Let the process work, so. Okay. Anybody have any other comments? Okay. So, could I have a, town council, make sure I'm doing
did you move to close the
I'm gonna
hearing?
move to close the hearing. Could I have a motion to close the hearing?
So moved.
Patrick, who's voting on this, just as a reminder?
So just to confirm, it would be the original group that voted on the night when the hearing was opened.
Okay.
So that would be all members.
Okay, so Mark, Bob, me, Drew, and Jane. Dave wasn't here.
No, Mr. Chairman, I think that's not correct.
Did you say he waved in though?
Oh, yeah, he did, yes. Yeah, so we
When
do
we
have a Mullen.
voted to close the hearings at that last meeting.
Dave.
Jane wasn't here. Dave was here.
No, that's not what he's saying. Patrick's saying Dave waved in.
Dave did provide a Mullen.
So you have your eligible 5 members, right? Jane waved in,
Right.
Mary Jane, I'm sorry.
That's okay.
Mary Jane waved in, Dave waved in. These 3 have been here since the night you originally voted. That's what I'd recommend, you have your
Oh, yeah,
5-member
yes.
board.
Okay,
Yeah, that's the
okay.
case, sure.
So the so it's the regular 5-member board that will vote on this. So to vote to close, we're gonna have the 5-member board vote to close the hearing. Okay. So we have a motion from Jane, it was seconded by Drew. Any further discussion? And this is just to close the hearing. Okay. The 5-member board, the 5 members, all those in favor of closing the hearing, please say aye. Aye. Opposed, abstained, okay, so carried. Okay. So the board has voted to close the hearing. And now could I have a motion to move denial of Darwin Commons 40B comprehensive permit application pursuant to the board's previous declaration that the denial of the application is consistent with local needs under certified compliance with the housing, with an approved housing production plan under the applicable provisions of 760 CMR 56.03, which has been appealed by the applicant but affirmed by the Massachusetts Department of Housing and Community Development by a decision dated November 24th, 2021, without further appeal. Okay, could I have a motion to that effect?
So moved.
Moved by Jane, second by Drew. Any further discussion on that? Okay. Everybody clear on what we're voting for? This would be denying the project because of safe harbor. Okay. All those in favor of denying the project because of safe harbor, please say aye.
Aye.
Opposed, abstained, so carried. Okay. So, that is denied because of safe harbor. Okay. Town council, anything else for guidance for the board? Nope, all set. Okay. Okay.
John, sorry, Mr. Chairman. Just while George is here, we do have a new business item regarding an update on board litigation.
What's that?
Well, Attorney Pucci is here. We do have a board business item on an update on litigation, so I
Yep.
just want to know.
To go to executive session?
No, you can do it open, John. I wasn't
Okay.
gonna get into too much detail.
Okay, okay. I'm gonna just let people clear out a little bit.
Just for your
The problem is,
You and Amy and
yeah, I mean, some of what they say is valid, some's useful, and then 50% of the stuff that,
Is it Pocketbook? Oh, she's right. Very.
Okay, we're still in public
Yeah, great.
session.
So
Do you
just
wanna-
briefly, John, I just wanted to update the board. I provided a, which I think was a great idea. You kind of
No, that's okay.
had me give a recitation of, you kind of had me give a description of pending litigation involving the board last time, and I gave an update. I think it's generally a good idea, since I'm here, to let you know what's going on in various cases. I have no updates on anything that we talked about at the last one, including Kearsarge and those are in the process that I described. One that there is an update on, though, is, for Dupie Street, we presented, consistent with the board's vote, a joint motion for a remand hearing. And I talked to Pat about when that would be, and that would be a remand hearing on that modification that they did. And HAC has deferred their proceedings until after that occurs. So further, litigation at the Housing Appeals Committee will be dependent on what the board does that on the remand.
So the
You're not
rem-
limited to that one night, you can have more than one hearing session, but as soon as you're done and you've decided, depending on the result, it'll either moot the appeal or the appeal will proceed.
And just so everybody's clear on that, that was so that the people, the neighbors could also hear what was happening.
Correct.
Okay.
So I just wanted to let you know that that's everything, because there was a whole schedule set up on that case before that happened, so. And then the only other one that had an update was Walsh Brothers, remember the house lot in the flood?
300 Stone Street.
300 Stone Street. The court wants to try that case under, it's called a case stated procedure, which is basically like a summary judgment proceeding, so that nobody has to come in and testify live or be cross-examined. So the way that case is going to go down is we agree to a agreed statement of facts with the plaintiff's attorney. And what those statement of facts will be is basically the record that was before the board. So it would be the peer review report, anything like that, we'll put before the court as evidence. And the court is going to do a site visit at that project site for March 18.
Yeah.
I provided Pat the date, and one or more of you are free to attend that if you want to. It's going to be at 8 a.m. on, I think, the 18th.
If you give me something written up, I'll forward that to the board.
Yeah, it's in March, and you're free to attend. And what he's going to do is, the briefing will be submitted in advance of that. The judge will do the site visit, which I think in that case is a great idea, because he'll see, you really got to see the site to be able to rule on that. He'll see the site, and then there'll be arguments from council following that site visit conducted by Zoom. So that's kind of the only update that's on that case.
But the peer review from GZA,
Will be before the judge.
but it's important that they don't just focus on one line that says,
Correct.
you know, that's key. The engineer said that, well, it meets the bylaw, you know,
Right.
intent, but, and then there was a whole paragraph of why it was unacceptable.
Correct.
So I
And we don't just submit it and let the judge decide. We agree to a stipulated group of material that goes before the judge. And the basic facts of the case, you know, the address of the property, the board conducted hearings on such and such a date, here are the reports. And then we file a brief, though, advocating what the record shows. So we would obviously be highlighting that in our briefing. So you don't just put it before the judge and let him decide what's relevant. You advocate, you know, based on what's in that record. And, you know, that's a cost-effective way of trying the case, because you don't have to now hire the peer reviewer to come in and be cross-examined and show up at trial and sit around and all of that. So it's kind of an efficient way of trying the case, and I'm hopeful that when the judge sees that site in connection with the record, that the board's decision would be upheld.
So at the site visit, who will be there?
Plaintiff counsel will be there, I will be there, the judge will be there, probably the judge's clerk, and then whoever we want to have there, but it's not, you won't be testifying.
Will the applicant be there?
Possibly, but
The
he
applicant's
has the
engineer?
right to be there, but,
Okay.
but it's not a time to,
I-
there's a certain amount of discussion and pointing out things to the judge, but it's not a place to be advocating to the judge. It's not, he doesn't take kindly to it if you
Okay.
do it that way. But certainly, you know, pointing out where the lot lines are and, you know, where the uphill and upland and down drain areas and, you know, that type of informational background can be provided to the judge there. So I would recommend we definitely have somebody there that has the ability to point out landmarks to the judge.
Could that be the consultant as opposed to somebody from the board, or would it be better?
I mean,
Could be, yeah, but, I mean, I would recommend either Pat or
Okay.
the, you know, chair, vice chair, or a combination, whatever you want. Pat would suffice if you'd prefer not to
Sure.
be there.
yeah, we do have the consultant's peer review letter.
That's right.
Which is
So-
kind of the basis of your argument.
And we can certainly talk further before, you know, before then about the way it's late in March, so there'll be time if you want to think about it and ask any questions about it, so. And that's
Thank you.
pretty much the only update.
Okay. So, timeframe for the Dupuy Street to come back for remand?
I talked to Pat about a date,
I think we talked about February 16th.
because I think Lou was in on another one that night.
So Burns was continuing to February 16th, so we brought that up as an option, so. I don't know how-
It's up to you. If you think it's too much, we can ask, you know, put it on a different night.
Yeah, I think I'd rather have it on a separate night, because it's, yeah, let's do a separate night later.
So I believe the next one would be March 2nd.
That's fine.
Yeah, if you could shoot me an
I'll send you an
email about
email.
that, yeah, that'd be great.
Is that okay for people? It's just, it's gonna be confusing for the public with two different hearings.
There'll be a lot of people in
Right.
attendance.
Yeah. Okay. You okay with that?
All set?
Okay, and final one, KW Steel, are they still, they're gonna vacate the property, that was the plan?
As far as I know, yeah, but it was end of March, not March, February, wasn't it, their
Okay.
lease? I haven't heard anything.
Yep.
And I told you before, that would not go over well with the judge
Okay.
if they don't move out.
Okay. Okay.
And I
Okay,
haven't, fortunately, have not heard any complaints from counsel for the neighbors that, you know, hopefully they're being a good neighbor in the meantime.
okay, thank you, George.
Thank you very much.
Thanks, George. That's all you know.
Okay,
Thank you. Yep, see you.
Next case is case number 21, 21.
Thanks, George.
18 Ponderosa Lane, variance under section 6B1, schedule of dimensional regulations for relief to the minimum side yard setback within the residential B zoning district. This was continued from, about 2 weeks ago, or no, the 5th, from January 5th. So, is the applicant here? And, very good. So why don't you come forward, present, yeah, to the microphone. Everybody has their map. This is all online, so hopefully people have had a chance to review it already. So at this point, what we ask you to do is just introduce yourself for the record and explain what you're proposing and what you're asking for a variance, and I hope somebody explained to you that about a variance and how that goes. So, okay.
Brianna Panero,
Chris Pinero.
and we are requesting a variance, as you mentioned, for our side yard setback. The plans that you guys have in front of you show the proposed addition going 7 feet into the side setback. We do not have any adjacent neighbors on the side where the setback is proposed, although there are streets diagonal behind us that can see the addition from their house, as well as our neighbor across the street from us. So the reason for the project, we have a very nice home in East Walpole. We love it here, and when we bought the home, we were under the impression, we had our master bedroom was on a different floor than our children, and we were comfortable with that. Since moving into the home, we found out that the previous owners there was a fire at the house, and the woman, had said to me, she's like, I was really hoping nobody with young kids moved in here because, being on different floors, and then, all of a sudden we've now bought this house and we have very young kids that are in different floors. So from that point on, I was kind of on a charge to get us all on the same floor, which is very difficult in a split level home. So we've worked with multiple architects through the last 2 years now to try and figure out a way. We've looked at keeping within the existing footprint. We've looked at going off the back. And finally, we reached this configuration that we have now that puts us on the same level as our 3 boys. And so that's what we're asking to do, and that's why it's off to the side. Our neighbors to the left, I don't know if that's a technical term, but our other neighbors, they're very close to us, so we decided we'd try and go off the other end so that we weren't disrupting them. Again, we're at a cul-de-sac. Technically speaking, I think the land that we're getting close to is owned by Old Post Road. It's at the it almost looks like it was like an easement of some sort, but it's all wooded property, and definitely not like one of the paved paths for the kids to go to school.
Yeah,
Is that good?
it's great. So just a little more background. So we have a family of 5. We have 3 children. The bedrooms, the way that they're situated in the home, are 3 bedrooms on the first floor, and then a master above that. So we're hoping to transpire a hardship on the grounds of security. Really, we heard about the fire last year. Our car was stolen right out of our driveway. We immediately put in a security system. Walpole PD helped us through with everything. We got the car back. Everything's good there, but nonetheless, on the grounds of security, we really want to have our entire family on the second floor together. I'm sure a lot of you guys are parents and can understand that, but really, that's the main driver to this entire project. Is just that's when we moved in. Shortly after we purchased the home in 2016, we found out about the fire. We had a lot of chimney companies come in, clean it out, make sure it was okay. Took care of that, and then again last year our car was stolen, so we.
Very safe town,
Yeah,
but
yeah.
we just seem to have these mishaps. So.
Right. So, and then again, like we've gone through several architects who've tried to solve this problem within the existing footprint. And again, like Brianna mentioned, the split level home doesn't really lend itself to doing that. So we had to bring it to the other side where the setback is violated a little bit on the Old Post Road Elementary School side. But yeah, no, I think that's it.
I think we covered it.
Yeah.
So with a variance, it's a very high standard for the zoning board to grant a variance. And we do grant variances. That's why you have a zoning board.
Yes.
And you have to explain, why this situation would allow the 5 members here to basically ignore the laws that the town has put in place. In your application, you've outlined, the circumstances, for it. But there's questions about the shape, the topography of the lot, and you actually have a very normal rectangular lot. So, do you have anything else to add about why the zoning board should approve this?
Yeah, sure. So, we've looked around Walpole. We've been on the hunt for a home in Walpole since, we started to struggle with this and trying to figure out how to put all of these bedrooms on the second floor. And ultimately, we haven't been able to find anything within Walpole, and they're not making any more land, so we can't find a place to build either. So we've exhausted as many options as we could. We've gone through the architects. We've gone through the different plans, and this is where we've arrived. That's why we're here, right? That's ultimately, we're requesting permission from the board here, and thank you for taking the time, Chairman, council members, to hear our case.
Can I add to that though too? Like on the, again, left side, plan left of our home, our neighbor is extremely close to us, and I think they, maybe, I don't know, if they went, if they have a variance or what the, situation is there, but again, there was absolutely no way we could add anything to the left side of our home, and again, that's why we pushed to the right. We even angled the garage addition so that the impact over the setback was minimal. And so, again, we're trying to mitigate as best we can with the least amount of disruption to our neighbors, who we like very much.
Okay. Dave?
I just have a question. Did you look at just going back instead of left or right?
Yeah, so actually that's part of our plan. If you looked at, if you see in the plans, we actually are going back, and we have to go back as well in order to create enough space for the third bedroom to butt off the house. So we're actually gonna put sono tubes in and bring the kitchen out and bring it up to the second floor, which right now is our 1-year-old's bedroom, which is like a small hallway. And as the kids grow older, obviously there's a bigger room with a proper closet.
And I apologize for not knowing this, but the rear yard setback is?
Rear yard setback is 30 feet. Side yard setback is 15 feet, and the applicant is asking to go within more than half of that, down to 7 feet.
Okay.
I believe if you're familiar with the zoning, the way the property is laid out for Old Post Elementary is it's almost like an easement that goes all the way down that actually separates us from our neighbor who's here. And that easement is all wooded. There's no, it's not an actual, like, people don't use it as an easement, it's just there and
But
wooded.
there's a walkway that's,
We wouldn't be impacted
Sorry,
by
it would be
walkway.
perpendicular to that walkway on the zoning. If you look at the map, it's just like a big L that goes,
Oh.
shoots out.
It's
And
not a paved
it's
path.
not paved,
over
it's
to,
wooded.
Morse Street,
Correct. I think so.
the street behind it.
No, it's isn't it Morse? Or Pepperell?
There's nothing, it's,
No,
Yeah.
not even that.
Talking about the footpath that connects.
Not the footpath going to Old Post, that adjacent, or that perpendicular easement on the zoning.
I mean, I'd say it goes back between Morse.
Is,
and,
yeah,
Yeah.
that's what I thought, okay.
I don't know where Morse is.
I think it's the next street down, where Frank's friend used to live.
Anybody else have questions or comments?
Oh, yeah, it is Morse Street. Right, not a paved path though,
Yeah.
it's just wooded.
Oh, yeah.
Judy?
I know we're not supposed to redesign, but you've got the garage at such an angle that causes you to have that 7-foot side,
Yeah.
side yard distance.
So if you turned it straight on to the road, you would be impacting that setback even further, because then you'd have just like a flat line across. The two-car garage width is set by, obviously, the size of two garages. It's a standard size garage, it's not, whatever, but turning it, we're only going over our setback in like a smaller location than if you were square, you'd be going through, does that make sense? Am I explaining? I don't know.
Yeah.
That's explaining right. Do you understand though, like if you went flat on, you'd be probably like 10 feet into the setback, but all the way across the depth of the garage. But because it's at an angle, it's only that back corner that's impacting, and it's only going 7 feet into the side setback.
Okay. Now, I might have another question, but typically, the three criteria, financial hardship, topography of the land, and character of the neighborhood. I did a drive-by, and there's a couple of big houses, but, with this addition, I'm assuming you're gonna be the biggest house on the street. And that's fine, but to request a variance of 8 feet is, to me, a huge dimensional request. And I understand that might be forest, like, it's an easement going from the Old Post Road School property owned by the town of Walpole, and maybe nothing will ever need to be put
See,
there.
no, I think we actually have to.
We
look
protect
at-
them, yes.
In fact, of all the properties in the neighborhood, that's the one the zoning
No.
board should really be looking
No,
at.
that's what I'm
because-
going, John, that's
Okay,
what I'm going,
yeah.
is that, you can't say it's only the town of Walpole that owns that
Yeah.
20-foot strip.
Mm-hmm.
That was put there for, I believe, a reason when the school was built, and I don't know if it was from the addition or prior to Windsor Road going in and all those things. Somebody thought of putting that there for probably a good reason that we're not
No,
aware
and the
of.
reason is because it does connect to the end of Moore Street, which at some point, if somebody wants to access from Moore Street to Old Post Road School, there's public land right there.
For what it's worth, I believe about 10 years ago or so, the water table, they had to do a lot of work to secure the water table, and they actually put a drain pipe that went to the beginning of that easement. And there actually is an easement now that children use between our house and the next neighbor. I think it's 16.
We're calling it an easement, but that's not, it's just a strip of land that's part of the big, larger property owned
For
by.
Old Post Road, but I do think you're correct. I do think it was there for a reason. I think the intent was to put, to allow people to walk from Moore Street into Old Post Road. I think the issues with the water table, when they fixed that, because our neighbors across the street had told us a lot about a lot of flooding that had happened, that instead they decided not to develop it. They put a drain there, and then they put the easement next between us and our neighbor.
But I think it's a strip that's, one, if anything was gonna go into it, it wouldn't be a structure, it would be like a paved path,
Path,
similar
yeah.
to the one that goes right in front of our house, all the way down to Old Post Road. So
Right.
right now, again, it's just wooded area. And so if they were to do anything with it, again, there's not enough space to do a structure, so if you paved a path, you could still go right up to our property line,
Yeah.
and we'd still be 8 feet off of that
That
path,
pathway,
if they ever
were
decided
yeah.
to pave it. Nobody uses that path. I've never seen a child go down
I
there.
use it sometimes for grass clippings.
But, and one other point, and I've dealt with many architects in my lifetime,
Mhm.
and when you ask them to design something, they really should design it to fit the codes.
Agreed, yeah.
And that's where I'll leave that one, because.
And that's where we ran into the issue where we went, 2 other architects, we dumped a lot of, unfortunate money into designing all of this and trying to work within the existing footprint. The architects we'd worked with before we had met with Jeff of Blackbird Architecture, couldn't resolve it for us. And this was like the only configuration that seemingly made sense and gave us what we were looking for as far as security with the children on the second floor with us.
And to comment on being the largest house in the neighborhood, we agree, and we're not, I mean, that was never our intention. But again, if you look around Walpole, if you look at Realtor.com, there are no houses for sale under $2 million
Yeah.
right now for a 5-bedroom home. We need 4. We both work from home. His mother, she doesn't live with us, but she visits often, stays over often. She would love us to put an in-law suite on as well, but just, you know. Just, you know, like we have done a lot of thinking about this. It's been over, like I said, over almost 2 years probably of thinking. We've looked in neighboring towns. We're not really interested in moving. We love Walpole and specifically East Walpole. We really want to make this work for our family so that we can stay here, because
And you guys-
finding another house here in East Walpole unfortunately does not look like it's going to be in the books for us anytime soon.
And if you drove by, you know our location, we have the Old Post Elementary School right there, our kids go to Old Post, they're gonna go to Byrd Middle School, and then they're gonna go to high school, it's just like, couldn't ask for a better
We don't wanna
location.
leave.
We don't wanna leave, yeah, we don't
But
wanna
we
leave.
need to find, you know, we need to make this work, and so that's how we ended up here.
I don't have, excuse me, do you mind if I ask?
Yeah,
a
go ahead.
question?
Yeah.
Did you ever, and I'm not designing, but I guess I'm just wondering to see if there's a hardship or not, but did the garage, did you ever look at turning it 90 degrees so you drive in and turn into it, or?
Yeah, there's a fire hydrant,
Okay,
yeah, so that's another, obstacle that we had to.
but I think there was a department comment about moving the hydrant in.
Yeah, there was. They were saying, I think they were saying if this design right now impacts that hydrant, that we would be responsible for relocating it to wherever the fire department directed us to. We don't believe that's the case, that we're going to impact the current location of it, but if so, we would take that on as a cost.
For what it's worth, I cut the grass around the hydrant.
That's very magnanimous of you.
Tries.
So, I think we should walk through the steps of, you wanna do
Was
that?
there any,
What's that?
here for the neighbors?
Yeah. Is there a neighbor that wants to comment on this, or?
The one thing I do say about, I thought, when you talked about the strip behind, I believe it is town forest, that does go to, Moore Street. I thought you said it was paved, which is.
Oh, yeah,
it's
no,
not.
absolutely not. No.
But, I mean, if you wanted to cut through, you could.
Yeah,
I think a lot of the issue is that there are things that, have fallen from the trees. A lot of trees, you know, have just age. In fact, my husband was saying today in the spring, he wants to go out there and clean it up some.
Mr. Chairman?
Yeah.
Mr. Zabutter, are you a neighbor? Where are you, on the other side of,
20 Windsor.
on Windsor, so you're on the other side of this
You're on the, you're right.
town forest?
They come up to the town forest and.
Okay.
cut the town.
Okay.
Okay. So, for getting a variance, as I said, it's a high bar, and, at least I'm not seeing it. Is there a reason you need to have a two-car garage, or, you know, because with a one-car garage in space above, you'd meet the requirement of the setback?
Yeah, I mean, going back to like the charge of the project and talking about the security, again, Walpole's a very safe town, but my car was stolen out of my driveway last summer. So having a two-car garage is definitely important to us.
and the biggest fear too was when it was still in the garage openers in the car, so they couldn't come into the house, and that's, kids are on the first floor, I'm on the second floor, we're asleep, like, it's just a scary scenario. You put yourself in our shoes.
Do you want to walk through the steps?
Well, I mean, I think,
Oh,
you know, as the chairman said, it's a very high standard. In fact, it's almost impossible to meet. But yet they are granted. And so I think on a couple of the factors, I think, you know, will there be detriment to the neighborhood? I don't think so. One of the unique features here seems to me to be that you don't have a direct abutter who would be affected by this. Yes, you're getting closer to the town land, but that's not, to me, just, it doesn't, you know, result in a detriment to the public good, or derogate from the intent of the bylaw. I think the purpose of the setback really is to protect neighbors, from one another, or at least have a respectful distance between them. You don't have a neighbor in this case, so I don't think that's as critical an issue. The one that's difficult, the part of the standard in my view, is whether there's something particular about your piece of property that isn't, you know, has a unique feature that isn't found elsewhere within the zoning district. And that's frankly difficult to show. Usually those are types of cases are where there's a ledge outcrop and you can't physically put, you know, the addition where you would like to put it. You have to put it here for other reasons. So, I mean, the board certainly has granted variances in the past. I think there's minimal impact associated with granting this variance, but I understand that, you know, the standard may not be met here. So I just put that out there for further discussion.
And just where you feel that the setback to that strip of land, I actually see that as a problem, because in the future, that could be the walkway from the other street, and to have a wall with 7 feet from a walkway, I actually think that could be detrimental.
Yeah, I mean, I was thinking if it was a footpath, yeah, it's just you're walking by it. It's not, it doesn't strike me as particularly detrimental, but I certainly am not, yeah, but it does strike you, so.
Anybody else? Judy?
Could you explain to the applicants if there's a denial, that they have to wait 2 years to come back with a different plan? Is that an accurate statement?
No.
No?
No.
They don't have to wait 2 years if, no?
No,
Okay.
no.
I thought you did, unless it's substantially different.
You said a different plan, so.
No, I mean, if this plan were to be denied, there could be a 2-year wait if they come back, if they think they're gonna come back with this same plan.
Right, if they
If
came
they-
with the same
Same
plan,
plan.
but you said a different plan.
If they came back with
They
a
can come back with
different,
a different
substantially
plan.
different
Right.
plan inside that 2-year window.
Yeah.
Okay.
But I actually don't think, we usually don't provide legal advice.
No, I didn't know if they were aware, okay.
Jay?
Mr. Chairman, I fully understand what they're up against here. And it's beautifully planned. What strikes me is the neighborhood it's in, but what it's going to be. I'm looking from this to this, and it's at the end of a cul-de-sac, and it just seems to me that it would be so out of place. I mean, and that is one of the issues, would it fit in with the neighborhood? I mean, it looks like this house was just obliterated, and we started out from scratch. I mean, it's absolutely beautiful, but that would be my only little whisper of a concern here, that it is so much bigger, any house on that neighborhood. And I am familiar with the neighborhood, and you're right, they did have major flooding. There never was a rain that they didn't have a puddle out in front.
Yeah,
Big
our
enough
kids like
that you-
jumping in them.
Big enough that you could almost swim in it.
Yeah.
I'm glad that's taken care of, but that's just my thought.
Okay.
It's huge.
Yeah, I did want to make note that one of our neighbors, we were supposed to come last meeting, but we both had COVID, so, one of our neighbors, you know, our neighbor across the street, who would be a direct view of this new home, she was gonna come in support of us, because she, you know, she understands our struggle, again, with the 3 young boys on a different floor than us, and it's like really, it's really challenging, for so many reasons.
No,
but-
I get that.
Yeah, so I wish she could have been here tonight.
Anybody else? Okay. So, unfortunately for the applicant, I don't feel comfortable granting relief for this. I don't know how other board members feel. But, I'll ask the applicant if they want to close the hearing. That is your option, to close the hearing and see how the board votes. The other choice would be to keep it open and, you know, come back with a revision if that's what you wanted, but I hope the building inspector explained to you, a variance is a difficult thing. It's
Yeah.
not you show up and get a variance.
No, we
didn't
understood
expect
that,
that,
and
yeah.
we heard mixed reviews from our potential contractors and our architect.
Okay.
I did hear, though, if you're already in your setback, that you don't have to reapply for a new variance. If like you're, like, say our neighbors to the other side of us, like they're already within their setback, they wouldn't have, if they wanted to build more along that setback, they wouldn't have to go back for another
That's correct.
variance, right?
So, as long as they don't increase we call it a nonconformity, meaning they don't increase
Right.
how close they are to the property line, they could add on, as long as they don't get any closer to what they already have.
Yeah.
But that doesn't, one of the things I looked at, you actually have a beautiful house centered on the lot.
Right.
It was built the way they're supposed to build them, and now what you want is a bigger house, and I understand it, but it's not staying within the parameters of what the town has set for the rules. So,
Not necessarily bigger. It's about the same size, and the current two-car garage that we have would just be infilled for storage space, because we don't have storage, like we don't have a standard attic. So it's about the same size. It's not that much bigger, I guess is.
Looks bigger, but
It looks bigger because
Yeah.
you're taking the garages and you're moving them, and you're taking the bedrooms on the first floor and moving them, but, yeah.
Okay.
Sorry.
Anybody else? Okay. So at this point, the board, and Patrick, do you have anything to add?
I think you explained it, the board explained it very well. Obviously, the parameters for meeting a variance, as I believe Deputy Commissioner Crowley explained to you, is a little bit stringent and is a little bit difficult, and I think you explained it to the board offered comments, so,
Yeah.
however you wish to proceed.
Okay, so at this point, you have your choice. You can either ask to close the hearing, and then we vote to close the hearing, and then we can render a decision. Or if you thought there was something that you might want to come back to another meeting with and say, you know, we can do something different, you could do that.
And that would be a change to the variance, as if, like, say we were to go down to a one-car garage and we violated only by a couple feet versus 8 feet? Is that the scenario in which you're referring to?
That's
or-
what I'm referring to,
Yeah,
but I'm
okay.
not giving you any
No,
guidance or
understood,
anything.
understood, just as
you know,
far as
but,
our options.
Yeah, so if you came in with a different plan that now had a 1-foot variance, you know, that the board might, you know,
Right,
have a different view of that, but I can't say. A variance is tough.
yeah.
Well, the other thing is, just a clarifying question, and just to go back to what Drew had mentioned, like if we turned the garages 90 degrees and then we came in at like coming around, so you'd only see like the side of the garage. In that scenario, our driveway would go up to our property line, so an additional 7 feet of pavement all the way up to our property line in order to accommodate like turning into a two-car garage that was flipped on its side. Which in my understanding is that you can pave all the way up to your property line, you can't build all the way up to your property line. So that would likely be the alternate, because it still gives us the same space, but now we're talking about a paved huge piece of asphalt that's going all the way to our property line, which is, in my opinion, less desirable for,
Aesthetically.
not even aesthetically, environmentally, aesthetically, like, there's just, tons of different reasons why I would prefer not to go down that path, but if that's the decision, we respect it, and we understand variances are difficult to get, we just,
We were hoping to transpire the hardship.
Yeah.
Okay. So do you want to close the hearing, or?
So close the hearing, you make a decision, and then we have an we could appeal the decision or come back with another plan.
Yeah.
But either way, if we change these plans at all, like, we have to resubmit oh, no, because if we're within our bounds, we just go ahead and,
Get full
Yeah,
permit.
correct. If it doesn't meet the need for a variance, then you would just proceed with a regular building permit.
Okay.
and then keeping it open is
Just
another, we would come back.
Subject to changing the plans, that would still violate a variance.
Okay, so we'd, just another variance request.
If
but-
you make
Are
a
very
change
hard to
that
get.
still requires a variance, then obviously.
So I guess
Which are
no.
still very hard to get regardless, so.
All right.
I guess we'll
We'll
close.
close it out and
close
let
the
you guys
hearing.
make a decision.
Okay. So at the request of the applicant, could I have a motion to close the hearing?
So moved.
Moved by Jane, second by Drew. Any further discussion on closing the hearing? All those in, regular 5 board members voting on this, all those in favor of closing the hearing, please say aye.
Aye.
Opposed, abstained, so carried. Okay, so the hearing's closed. I've already said for the record, unfortunately for the applicant, I don't see that this rises to the level of a variance. Other board members, how do you feel?
To make a motion to deny the request for a variance.
Okay,
Second.
okay, second by, motion made by Drew, second by Dave. Any further discussion on this? Okay, I will add, so, Drew, could I modify your, motion to deny without prejudice?
Yep.
So that, and that just helps you, that if you wanted to come back with another plan, there's no question that you can come back. You don't have to wait the 2 years that Judy was talking about. Because you could do it with a revised plan, but it would have to be, significant. But that's just trying to protect you, so.
Appreciate that.
So we have a motion to deny without prejudice before us. Any further discussion on that? Okay. All those in favor of denying the request for variance, please say aye. Aye. Opposed? Abstained? So carried. 5-0-0. Okay. Okay.
Crushed it.
Sorry about that, folks. Yeah.
Thank you for your time, Council.
Thank you.
Okay. Next, we have on the agenda for new business. I asked to put this on for discussion about having the meetings here at Town Hall in person. What's the consensus of the board? We know we're in a time of COVID. Other boards, some boards are meeting, some boards are not meeting in person. I think we can do it safely and with risk mitigation, but I put it out to you. How do other board members feel?
We've been meeting last 2-3 weeks, and it's probably been the worst it's ever gonna be, hopefully.
And now
We
it's,
managed and we keep going.
and now it's 5% lower
Yeah.
than it was a week ago. So the general consensus seems to be that it's on a decline. And if it follows what it did in Africa, where this originated supposedly, they had a sharp decline after a certain period of time. So, I don't know, I would much prefer that we do this in person. Not personally, but I have to say that I do feel, and while some people feel as though more people can get to see it if it's on Zoom, I think a lot of it is lost in translation here. In other words, I think there could be a lot more give and take. If people are opposed or pro for something, or they want to make a comment, they can come here, they can say it publicly, other people can see it. When it's done, I think there's a certain reticence on people to get involved in that. We just assume that everybody has a computer and everybody has this and everybody has that. Well, I, for one, I have all those things. Do I know how to run them? Absolutely not. Without my granddaughter, I'm lost. But there are a lot of people who may not have these necessary electronics, and people who may not really use it, and those people who are reticent about doing that. So I think a lot is lost in translation, so I'd like to see us continue to do it as long as we could. And I think we can do it as safely as we have in the past.
I'm in favor of in-person.
Okay. I think tonight's meeting showed that people did feel that it was important we had a full room.
Oh,
So,
yeah.
No, I agree. I think it's preferable to do it in person. I didn't know if Jim Johnson's memo was sort of a directive to all boards to not meet or not. I didn't know what
No.
to make of that, so that's why I
It
raised
was
the
an
question.
advisory to us, but we could make our own decision, and that's what I asked, that's why I'm asking everybody, so, good. Okay. Judy?
I weighed in on email,
Okay.
yes,
Yeah,
for in
yeah.
person.
Okay, I think it's
Because
better
we have public
for-
hearings, it's a different, if the select board wants to meet by Zoom, they just conduct it, I mean, not just, but they conduct business. They might have an open forum for something, you know, at the end of their meeting or whatever, but, you know, we have hearings, we have people that
Right.
want to be in front of us. I want to see the overall reaction of the room, and I want to see the overall reaction of our board members. I mean, I want to just kind of read you guys too. You can read me like a book, I guess, but I think it's important that we move on and live on and carry on and just do what we have to do to wear a mask, not wear a mask, wash your hands,
Okay,
Is what we
Okay.
would say.
well, that answers that question, so that's good.
Okay.
So, next thing, the minutes. Minutes from January 5th. Pretty straightforward. Looks good. So we went into executive session, so we're gonna have to vote on two parts of this, but
Yeah, so the executive session minutes, I put it on the agenda. I decided not to go forward with it until the previous meeting, because I got it done a little bit later. So I'd rather kind of move that to your next meeting in February for the
Okay.
executive session minutes.
okay, so just hold off on approving those minutes?
We don't have them anyway, we just have the.
But we have the regular.
We have the regular minutes, not the executive session
Okay.
minutes.
Is there any reason that we should approve both of them at the same time?
I don't think so.
I didn't think so,
We have to.
yeah. Could I have a motion to approve the minutes of January 5th, and then we can have further discussion if anybody has anything on that?
So moved.
Okay, moved by Jane, second by Drew. Any further discussion and comments, anything to change on it?
On the first page where it says also in attendance were, and that lists several people,
Oh, yeah.
including some folks who, from the public who spoke, but I think there were more than just those people in attendance.
Yeah, no, I'll have that removed, because I know they're mentioned within the minutes themselves, so we don't typically need to include
Okay,
people
yeah.
that spoke within the attendance,
Okay.
other than,
Good.
town council's here, I'm here,
Yep.
so.
And then on the top of the second page, the third paragraph down, second to last line. Substantial application under remand order from the Housing Appeals Committee. The applicant has 6 months to hold a public hearing. I think that should be the board has 6 months.
Correct.
Okay,
And that's all I got.
I guess so.
With those modifications, this would be to vote to approve the minutes of January 5th. If you were here at the meeting, you can vote. Okay, all those any further discussion? All those in favor of approving the minutes of January 5th, please say aye.
Aye.
Aye. Opposed, abstained, so carried. Okay. Okay. Does anybody have anything else for the board?
So I do want to introduce you all. Steve Natola is, this is Steve's second week. So Steve started as the permit coordinator, which is also the position that reports to you, the zoning board, as your secretary. So Steve is just second week, getting going, learning the ropes. So he'll be filling in similar how Amy filled in, taking notes, providing kind of that first person contact between applicants and yourself. So everybody. Steve? And,
Hi, Steven.
everybody. Yep.
Welcome.
Welcome.
And it's such a key, I'll just say, it's the face of the board. You're the first person people meet when they come in, and that's great. We're really glad to have you here.
These the minutes we called up to.
Anything else? Good. Could I have a motion to adjourn?
So moved.
Moved by James, second by Drew. All those in favor, please say aye.
Aye.
Opposed? Thanks, carried. Okay, good night, everybody.
No.